haven't got my notebook with me. That's on my desk. Sorry, I have my notebook on the desk reading your submissions over while eating a sandwich.
I hope it didn't cause indigestion.
No, it wasn't the submission. But do carry on. You, yes,
Sure,
yes, yes.
mind waiting. Okay. Yes. That's right.
Good afternoon, my ladies. Good afternoon, my lord. I'm very grateful for the opportunity. Just one discrete point
Yes.
there's risen over lunch. It relates to your ladyship's questions about the interrelation between the inspector and the Secretary of State, and also the point on the ramifications if this were to be taken into account. And the one element that I didn't draw to the court's attention, but I think would assist the court, is how it's dealt with in the procedure rules themselves. And this is, I'm afraid, there's not a copy in the authorities bundle. It is cited in the judgment, though. This is Rule 17, core bundle, page 120 to 121.
Yeah. Got it. Yes.
And in particular, Rule 17, subsection 5, which is relating to what occurs if, after the close of an inquiry, the Secretary of State, and there are two elements here, we're concerned with the second, takes into consideration any new evidence or new matter of fact not being a matter of government policy. And it notes that, and is, for that reason, disposed to disagree with a recommendation made by the inspector, shall not come to a decision which is at variance with the recommendation without first notifying in writing those who are entitled to appear as to the disagreement and his reasons for it, and firstly allowing written representations, or asking for the reopening of the inquiry. And the relevance of drawing this to the court's attention is twofold. Firstly, it shows that it isn't necessarily the case that the Secretary of State, taking into account the Arrett review, would have led to the inquiry being reopened. Yeah. First, the Secretary of State would have to consider whether, in fact, it didn't make a difference to the inspector's recommendation. If the Secretary of State concluded it did, then offered the opportunity for written representations or concluded the public inquiry. And the second point that we say is drawn from this is it shows that the procedure rules envisage that it may be required to accord with the statutory duty to go through the cost of the reopening of an inquiry, since it's provided for. And therefore, we say what the Secretary of State simply can't do is disregard an obvious material consideration, and obviously material consideration. They must consider, in effect, how to deal with it under the procedure rules. So I hope that assists just in terms of putting the procedural bones on what the exercise that the Secretary of State should have followed.
The other two things you might want to say are, one is presupposes there must be some circumstances in which new evidence is admissible, otherwise you wouldn't have the rule at all.
Yes.
And secondly, I imagine you'd submitted paragraph 4 that when it says, when making a decision, the Secretary of State may disregard any written representations or evidence received after the close of the inquiry. He couldn't do that if it was a mandatory material consideration.
And that was a point recognised by the learned judge in the court below, where recognised that power still has to be exercised lawfully. Yes, my lord. Unless I can assist any further, that was just the discrete point I wish to raise.
It's really helpful. Thank you very much. We needn't trouble you on ground 2. If there's anything you want to say to us about ground 1, then obviously we're interested in that. That's the point of principle.
It is. It is. Thank you. Well, I'll focus in that. I won't say anything about ground 2, and I'll focus on ground 1. My ladies, my lord, good afternoon. Ground 1, point of principle, rests on what is alleged to be a tension between two lines of authority, it is a tension that, as I'll show you now, does not exist. It simply does not exist. And with the greatest of respect to my learned friend, the reason it's even presupposed to be one is because of a misapprehension as to the nature of one of the lines of authority, in particular the Mead case, which I'll come to now. The two lines of authority cover completely different points. One of them, and I'll just summarise it as the Caides line of authority, obviously it's Caides in the subsequent cases, some of which you've been taken to. The Caides line of authority deals with what matters planning decision makers should have regard to when they're making planning decisions under section 70, Town and Country Planning Act. That's what Caides is about. The other line of authority, which is, if I just call it Mead for short, which is to say Mr. Justice Holgate as he was then, and what he said in the Mead case. The Mead line of authorities is about the things that putative claimants in court are entitled to raise as part of statutory challenges when they're seeking to bring section 288 challenges to the decisions of planning inspectors or the Secretary of State. The first line, the Caides line, is substantive in nature, which is to say it goes to the scope of planning issues that decision makers should consider when they're discharging their statutory functions. The second, the Mead line, is procedural in nature. It goes to the circumstances in which legal challenges to planning decisions can be predicated on matters that weren't before the original decision maker. These are two different sorts of point, qualitatively different, analytically different. And this basic premise reveals, again, with respect to an analytical flaw in the appellant's case, because it is suggested, see the appellant's skeleton, I won't take the court there, but see e.g. Paris 53 to 54, but it's put in different ways elsewhere. It said that these lines of authority cover the same so-called issue, but from different legal angles, as it is put, or different lenses. That's the metaphor that's used. But again, with respect to our submission, that's wrong. They don't cover the same issue from different lenses or angles. They cover two different issues, and that's what the judge below understood perfectly well. There is, of course, it's been emphasised this morning by my learned friend, no suggestion that Mead was incorrectly decided as by Mr. Justice Holgate, as he was then, or indeed any of the other cases that are relevant to that line of authority. In consequence, for the appellant's case on ground one to work, which is to say that the judge below in our case was wrong to rely on Mead, which is the nub of ground one, wrong to rely on Mead. For that to work, if Mead wasn't wrong, and no one's suggesting it was anything other than correct, if it's not wrong, there's got to be a material distinction on the facts of this case that take it outside the principle which was enunciated in Mead. I'm going to show you what the principle actually was that was enunciated in Mead in a moment, but that has to be the logic. But in the end, there is no material distinction. So,
well, does that mean, just thinking about the ramifications,
yes.
In practical terms, let's suppose you've got a Caides situation. Maybe not this case, but let's suppose you have got a Caides situation that arises in circumstances such as this.
Mm-hmm.
So there is a material factor which comes to light after the report, but before the decision is made. Mm-hmm. Right. So let's hypothesize that it is something which a decision maker it's blindingly obvious that they should take it into account, and it's contrary to something. Let's make it as closely analogous as possible. That new factor, shall we say, gives the lie or undermines something that the inspector thought was really important. Right. So you've got a material consideration, and it arises. Do you say that as a result of the Mead approach, you're always going to be shut out from raising that in a section 288 challenge if you haven't raised it with the decision maker.
You will normally, but not always. And the easiest way to unpack that might be to actually turn up Mead and
Yes.
just go through what's actually said.
Yes.
But it would be fair to say, so I'll just characterise my submission as being, but on the hypothesis that my lady sets out,
Yeah.
the normal position would be that a putative claimant would face the procedural bar that Mr. Justice Holgate, as was, identifies. However, that putative claimant would also be able to avail themselves of the exception to the bar that Mr. Justice Holgate, as was, relies on, because one thing the Mead does not do is to set out an absolute prohibition to doing anything at all.
Yes.
It always rests with the discretion of the court. So, to make that good, if we just turn up Mead, you were taking some of the paragraphs, so I'll just show you a couple of others.
Yeah.
Mead is tab 15 and the authorities relevant section from page appeal bundle page 410 and following. The court has that. So you were taken to the paragraphs that run up to 178, where it's said that if Redrow had submitted, there was a substantial lead, etc. That could have been would have been a significant factor to be addressed in the balance, in the overall planning balance. Mr. Justice Holgate said.
Well, it goes so far as to say that it was arguable, it was an obviously material consideration. So we're actually dealing with
the
that
potentially
particular
strong,
ground 3
exactly right.
irrational.
That's
Yeah.
exactly right. Yes. And then goes on to say 179. The problem was, as I accepted, that was not, that argument had not been made to the inspector. We didn't consider it material, let alone obviously material. It was not raised as a substantial issue. So that was the problem.
No, it's the next sentence, because the question is what error of law was alleged, if I not be the case.
Yeah.
And he couldn't be said to be acting irrationally for not dealing with an argument that
He
wasn't
didn't have.
put.
Precisely.
And he didn't have to give reasons for an issue that wasn't raised. That's all that paragraph 179 appears to decide.
Yes, but it goes on. 180 goes on to say there's also an objection to the raising of a new point of this kind in a statutory review in the High Court. If Redrow had raised at the public inquiry the point now advanced, then other parties, that HBC was the local planning authority, and other participants would have had the opportunity to adduce evidence if they thought appropriate to make submissions. Just as important is the point that the matter could have been addressed in a single process. The inspector would have been able to make additional findings of fact, evaluate weight, etc.
Of course, none of that reasoning applies to something which emerges for the first time after the inquiry or the report.
The reasoning applies to matters which are capable of being brought to the decision maker's attention before the decision's taken.
Well, you have to say it applies by analogy.
By analogy, that's right.
Yes, I mean, it doesn't directly apply because what the judge there is dealing with is matters that could have been raised at the public inquiry. So you can well see that if somebody doesn't raise a point at the time of the inquiry or before the planning officer makes his report in whichever case we're dealing with, then he can hardly turn around and say, oh, well, I've now had second thoughts, there's a material consideration and I want to raise it now.
Well, that's right, Molly, but the reason that I say that it does apply, perhaps it applies by analogy, but the logic applies, is because that phrase in a single appeal process,
Yes,
is at the core of what the judge is referring to.
yes.
That it would still be a single appeal process if post the first inquiry, the inspector or the Secretary of State in this case says, everybody, I've come across a new document and I need further written submissions on it, please, before as happened here. That's exactly what happened here in relation to the new MPPF.
Yeah.
I need more information on it before I make my decision, please. You've got until next month to do it. That's what happened. Written submissions ensue. The Secretary of State says, right, I've got all I need now, I'm going to go on and issue a decision. That is a single appeal process. There's no need to reopen the appeal
The
process.
judge clearly isn't talking about that there.
Not on the
I
facts
understand
of
you
that
can
case.
take those words out of context, forget the other 200 paragraphs and say a single appeal process is capable of covering all the following. But he wasn't talking about that, he
Well,
was talking about the inquiry.
He was talking about an inquiry, but there was no need, would have been, no need in this case, had the appellant actually raised the document that they now
So
criticise.
this judge is only saying that if you raise a point and it doesn't even say evidence, although presumably it had to have been evidence to back it up.
Yeah.
If you raise a point, you can't then, if you don't raise it, you can't complain about irrationality or
That's right.
failure to give reasons. And if you can't do that, you can't raise it for the first time in the High Court either. That's what he's saying.
That's what he said. That is what he's saying. That's right. And he goes on to say, and he elucidates what he calls a general principle in 181 towards the bottom of the page. But just to get there, he says that if the court were to quash an inspector's decision because of a new point of this kind, it would probably be necessary for the appeal process to be repeated in its entirety or in large part. Just pausing there, I'll obviously keep going through 181, but just pausing there to give the court a cross-reference. The judge in this case, in our case, found at 79 that the consequence of the appellant's case succeeding would have been that the inquiry would have needed to be reopened.
I've written why next to that in my
Well,
paragraph.
why? There
Because
was.
what Mr. Riley-Smith said is right, isn't it? It would all depend.
I'm sorry. It would be what?
Mr. Riley-Smith said about Rule 17, it would all depend.
It would depend, but there was the nature of the arguments before the inspector and the Secretary of State was summarised in correspondence, including at, if I just give the court a reference, supplementary bundle 333 and 334, which is one of the letters that postdated the inquiry, where it was suggested, and the suggestion was never rebutted by anybody, and still hasn't been, that the, I'll just let the court get there if you're there, my lord, it's the letter dated the 16th of Feb 2024. It was suggested to near the bottom of 333 in a series of bullet points that, well, I'll read them out. It was the document, because it hadn't been relied on by the council, was inconsistent with the council's evidence. The appeal, including concessions made in cross-examination, wasn't referred to or relied on in the council's response, etc. It was suggested over the page at 334, final substantive para, if any reliance is to be placed on these comments, the inquiry would need to be reopened, so they could be subject to cross-examination, which may result in an application.
That's what Stante was saying.
Rule 17, has she? It would only have to, if the Secretary of State reads this, and if it causes him to disagree with the recommendation, i.e. he's going to dismiss the appeal, not grant it, then he must give notice, and if requested. If he reads and doesn't make a blind difference, he doesn't. So if she's saying it relies, she means it's a shorthand for what's in paragraph 17.5, then it's all right. But this doesn't help really. Somebody's letter.
Well, no, the reason I take you there is because you asked me why was the judge reaching a view that the claimant's claim, if successful, would have necessitated the reopening of the inquiry. In my submission, the judge was absolutely right, because what the claimant, or now appellant, was saying is that yes, there's this document that's emerged, but not only that, the document was of fundamental importance to the merits of the case. It was so obviously material, it would have been irrational not to consider it. On the basis of the appellant's case,
considered it, she then, or he, whoever the Secretary did, then decided that it was a reason, and this case authority falls into your doors on the test. If you're going to depart from the recommendation, then you have to have the inquiry. But that proves Mr. Riley-Smith's point. It's because it's so important, and it's because the Secretary says, oh gosh, we've got this one wrong. That's why you go back. It's important.
no,
It's there in the rules.
Yeah.
I accept that the rules don't impel a new inquiry to be held, but that's not my submission. I took the court to 79 of the judge's judgment below, because she identified, and in my submission correctly, that the effect of Mr. Riley-Smith's claim or ground is that the consequence would have been the reopening of the inquiry.
We don't know. She's wrong about that, because we simply don't know. We don't know what the Secretary of State would have made of it. It was a submission that was made to the Secretary of State by one of the interested parties, not incidentally by the claimant.
No, that's correct. Well, there we are. The point is, back at 181 of the...
I think the most you can put it is that there is a danger that it might be reopened, to which the answer is, but that is a danger which is provided for in the rules.
It is a danger which is provided for in the rules. That's true. I do say that. Well, anyway, I've said it. I'd say that the judge was right to find that the effect of the appellant's position would have required it to be reopened, because it wasn't just the appellant who was saying that there was a problem. It was the other parties to the appeal who were saying this new document is inconsistent with evidence that's been given on behalf of the council in cross-examination. And in any event, back at 181 of Mead, at the very least, the same inspector or a new inspector would have to receive fresh submissions and prepare a new decision letter and evaluate the various policy and planning considerations all over again. The general principle is, and this is obviously, when I said there's a general principle, here it is that new evidence and or new submissions should not be entertained as a basis for quashing an inspector's decision, if this would mean an inspector would have to make further findings of fact and or reach a new planning judgment.
Well, nobody would quarrel with that as a general proposition, because you're dealing with a situation after the decision's been made. So the decision is made. Somebody then comes along and says, "Oh, excuse me, I've thought of a point which might be materially important, and it could have made all the difference." Answer: you're too late. Finality, as my lady puts it, finality is important here. You can't have second thoughts. You could and should have raised it. That's one thing.
Yes.
Then you're dealing with the Kedis sort of line of authority, which is really dealing with the unusual scenario where something emerges after the event, and I mean after in this context, a preliminary view, which nobody knew about at the time because it hadn't happened, and they couldn't have known about it even if they might have thought it was in the pipeline. And then the question is, are you, as a matter of procedure, precluded from raising that if you haven't raised it with the decision maker? And you say, by analogy with Mead, that's the whole thrust of what Mr. Justice Holgate was getting at here. Or is it a matter for judicial discretion, pure judicial discretion, depending upon the facts and circumstances of the individual case?
The question of judicial discretion is one that Mead leaves open at 182. So I mean, the answer is it's both of those things, because the Mead approach. So I'll just read out 182 and then I'll answer it directly. 182, as in civil proceedings more generally, resources, and this goes to a point that my lady was making earlier on. Resources for planning inquiries and hearings are finite. They need to be distributed efficiently between all parties. There's therefore a strong public interest in the finality of such proceedings. Parties are generally expected to bring forward their whole case when a matter is heard and determined. No proper justification has been advanced by the party in that case.
I'm going to read the whole thing just for the court to exercise discretion.
I was going to
keep reading. A new point which could have been but was not raised.
Yeah.
Exactly. No, and so here I appreciate them by analogy. That my submission is that logic extends where it says raised before the inspector. I'm asking the court to read in the Secretary of State, because the Mead case involved, obviously it was just a more straightforward inspector decision.
It's a normal planning appeal.
Normal planning appeal.
Decided the appeal and the Secretary of State.
Exactly. So this is a different fact pattern in that way.
Yeah.
But here, there it was the inspector who was the ultimate decision maker, vested in the authority from the Secretary of State. Here, it's the Secretary of State who was the ultimate decision maker. And so it's the same thing. If there was a new point or new evidence or whatever, new document or whatever, that could have been but was not raised before the decision maker, they're the inspector here, the Secretary of State. Well, okay, in theory, could that form the basis of a judicial review or a Section 288? Yes, in principle, yes.
Yes.
But exceptionally, in the discretion of the court, and that'll be weighing all of the public interest factors that Mr. Justice Holgate sets out. Because
why would a court conceivably think it right to say to a claimant who says, and we can't go behind the statement, I didn't know I could write into the Secretary of State. The rules don't provide that they can write into the Secretary of State, and something has happened which is so obviously material, it would be irrational to leave it out of account. And why should the court say, tough?
the judge below said tough, because
I could agree with her though.
well, because she made findings that the claimant would indeed Firstly, that this is at 75 and 76 of the judgment.
Yeah.
She had no doubt at all that the appellant, had sufficient confidence and skill to ask the inspector and or the Secretary of State to consider and seek representations on the out review if they considered it would further their goal of protecting the green belt. And further, the judge found that they would have been able to obtain professional advice on the possibility of relying on the out review if they wanted to.
If the judge had expressed her conclusions as a matter of pure discretion,
Sure. Yes.
then one can see that might be justifiable on the basis that she has evaluated the evidence. It's not for us to interfere with her evidence, with her evaluation of the evidence. And she says, well, you jolly well could have raised this before. I don't accept your explanation for not raising it before, and therefore we're in Mead territory, and as a matter of discretion I'm not going to allow you to raise it. But the way in which it's expressed seems to be much more as a matter of principle, and I think that is the concern that the claimants had.
Could I,
Paragraph 78.
Yeah.
but also para 80, where the judge says, he recounts what's said in Mead about resources, etc., and finality.
So she's recognising that the court does have a discretion.
Yeah, exactly, that's my point. She says that no proper justification has been advanced by the claimant for the court to exercise its discretion, exceptional. So she's applying Mead, obviously. She's applying the principle in Mead. And so she's not suggesting for one moment that this is some sort of absolute hard and fast rule. She's accepting the court has a role to exercise its discretion. She's reached a series of findings of fact as to the ability of the then claimant to...
She's reached that conclusion on the basis of paragraph 78. And is paragraph 78 right? It is failed without good reason to comply with the fundamental obligation on parties to a planning appeal to place before the decision maker the material on which they rely, and not to raise points for the first time in a High Court challenge. It refers to West and Mead.
Yes.
The question is, does that principle apply with the same force to a mandatory material consideration which arises for the first time after?
All one could... I mean, the answer is yes, but to the extent that the substantive grounds of challenge on which a claim are being brought are relevant, it may go to whether the court exercises the discretion, or how it exercises the discretion that the judge identifies that she had at paragraph 80. I'm not seeking to circumscribe the exercise of that discretion for one moment. It's a matter for the court.
Where's the fundamental obligation? Just remind me which rule or case says that you've got to tell the Secretary of State after the inquiry is closed if something new has happened. Paragraph 78.
Sorry. Well, it flows out of the West and the Mead cases, which is to say that the rule, the general rule, and it's an important rule that's been recognised in decades of authority, is that if a party wants the inspector or the Secretary of State to
Somebody
do
was
something...
whispering 65 and 66 of the judgment.
Yeah, that's right. That's right. And
She takes and derives the...
that's where she derives the principle. And, you know, with respect, she's right. No one's for one moment in this court suggesting that those principles are anything other than correct. That if you want, generally, not always, see
The
Thames
question for
side...
this court is whether they are applicable in that form to a material consideration which arises after an inquiry has closed.
And
That's the question.
that's the question. And the
And
most...
Western Mead
Sorry.
simply doesn't decide that. And if she's saying Western Mead imposes a fundamental obligation, then she's wrong. If she's saying should be extended, so it does apply, then it's a different question. The question is she right or not?
My submission is that West and Mead do decide. I appreciate that they don't deal with the precise sequence of events with a recovered appeal or a called-in application where there's an inspector and a Secretary of State in the same factual pattern that this court has. I accept that. But the principle, the fundamental principle that from which the judge inferred her general rule is sound across the piece, and it's a fundamental principle that has nothing to do with the substantive nature of the grounds upon which a challenge is based. It's not about the grounds. It's not about the basis upon which you're challenging a decision. It may be that you're bringing a Clydes challenge. It may be that you're bringing a
You say it can't be about the grounds because Mead makes it very clear that you're taking a situation where it's hypothesised, it's a material consideration in the irrationality sense that you'd be bonkers to leave it out. And so if it's good in a Mead situation, then it must be good in other situations where it's material in that sense.
That's right. I say that where all of this comes from, the Mead and West line of authority, is the courts, and it's mostly the court below. Although there are some statements in this court that are supportive, but the most elaborate statements of principle come from first instance.
We're bound by Bath and Major Crombie's success in Bath,
Yes.
and by Baroness Cumberledge's success in Sussex.
Of course, but
And
neither of those go to the point, because both of those cases are about the substantive scope of the Section 70 obligation to have regard to things. And what Mr. Justice Holgate, as was, is getting at in Mead is something different. He's not saying that the decision maker didn't have to think about X, Y, or Z. He's saying that if you want to bring a challenge, if you want to procedurally bring forward a Section 288, well, here are some circumstances where you're going to struggle.
I can't remember whether Major Crombie knew that the field had been designated and didn't tell anyone or not. But if he did know and didn't tell anyone, then he shouldn't have been allowed to win. And the same with Baroness Cumberledge. On your case.
I'll check.
You see my point, obviously.
Yes, my point is that the general rule that is derived from a number of authorities, but say from Western and from Mead also, that it is incumbent on parties to a planning appeal to place before the decision maker the material on which they rely, is a rule that applies not only to a conventional planning inquiry, but also to what happened here, which is a recovered appeal, where you have an inquiry followed by a Secretary of State decision. There is no rationale for excluding the operation of that general rule in certain sorts of appeal. It applies across the piece, and the justification for it is general, not particular. And it does accord with what Lord Justice Pill said in the Dyerson case, which is also in the authorities bundle, which was that an appellant must be expected to tell the inspector all he wishes to tell him. Many years of authority making this precise point.
We're not dealing with the inspector, we're dealing with the Secretary of State,
Well, no,
we're dealing with a situation after the inspector's opined, where something has arisen after the inspector has opined. So you can't just extrapolate from one to the other. I mean, we are dealing with a very different situation. We're dealing with potentially an extension of the principle.
Yes. Well, okay, in that case, I do need to make clear that I am seeking or asking the court to take those principles in Mead and the other ones I've just referred to, West and Dyson, and extend them by analogy to the factual scenario in this case.
Because the case is the only authority for that which it decides.
Yes.
And it only decided that if during the course of an appeal, in the course of a hearing, there was a point available to you, or if you wanted more evidence about the impact on you, you must tell the inspector. It decides no less than no more than that. It doesn't deal with the situation either where the inquiry is closed and it comes up, nor does it deal with this where there's a recovered appeal.
I accept that the fact pattern in Mead was different. I do say that the logic...
You say there's a principle, it illustrates a principle which applies throughout the appellate
I do say that. I do say that, yes, I accept that when Mr. Justice Holgate says inspector, one must read in here Secretary of State. I accept that there are factual differences in the way the procedure works, but I don't accept that any of the factual differences are material to whether the principles are good or bad. And in fact, I'd say that they do apply across the piece.
There is a tension between this and certainly first instance Cumberledge, Mr. Howell's decision, because Mr. Howell's decision, even just looking at the head note at 135 at the last paragraph, although the prescribed procedures which apply after the close of the adversarial part of the procedure do not necessarily preclude the submission of further relevant information, they are not designed to secure that the participants provide it. So there's no mandate to provide that further information. And I can see a tension between a situation where there is an obligation to bring forward your whole case before the inspector or before the decision maker at one stage, and a statutory process which doesn't expect you necessarily to do it, because there may be obligations, for example, on the decision maker themselves to, as where there may have been some other pertinent decision that neither of the parties could have known about.
I do. I see that. I just to take that in stages. That head note refers to when you were taken, I think, to the bit in the judgment of John Howell that went into this before the close of the adversarial part of the proceedings.
Yes.
That phrase, and it was suggested by my learned friend that obviously that must mean the planning inquiry essentially.
And that's what he was going on about. Well, we used to have them.
Well, it may have been there, but this was a case. This
normally knows what he's going on.
Oh no, I'm sure
Generally
he
does,
does. No,
yes.
I'm saying it may have been in the facts of that case, but on the facts of this case, the adversarial part of these proceedings did not begin and end with the planning inquiry. The adversarial part of these proceedings went on well into 2020.
Didn't just stop with the inquiry.
The
only thing that happened afterwards was the Secretary of State wrote.
Paragraph 101.
yeah, no, but
of
the
judgment.
that led to an
166.
adversarial exchange of written representations. That was, they weren't orally tested, but that was all part of the proceedings before the Secretary of State. He could have, of course, decided, well, I'm going to reopen this inquiry, but instead he chose to deal with it as he was entitled to through a written exchange. But that was adversarial, absolutely adversarial. The parties were flat out
There
disagreeing.
may be an element of adversarial to it. If one looks at Mr. Howell's 101 in its full context.
So sorry, let me just turn that.
Page 166, over the
Thank
page
you.
107 to 67. But actually, if you read the whole thing in context,
Yes.
what Mr. Howell is saying is that once you get to the stage where the Secretary of State's looking at it, it's not merely adversarial, because there are duties that overlay
Yes.
that.
Yes, yes.
And there is a difference in practice, he says, that between the position that applies until the end of the inquiry or hearing and or the final submission of written representations, and the position that applies after that until a decision is reached. So he is drawing a distinction between pre-inquiry and post-inquiry.
Yeah.
And I think what he must mean by the adversarial part of the proceedings, he must mean the former, not the latter.
Yes.
In
certainly may.
context, I think that is absolutely right. It's shorthand for the first part that he's describing.
I accept that may well be shorthand for what he's describing. My submission is, and I do accept, by the way, that what happens after the inquiry is finished in a case like ours is not merely adversarial.
No.
I do accept that. Of course, I also accept there are obligations. There could be a common law obligation on the Secretary of State to go off and find new material himself on the C10 side. However, I do not accept that the adversarial part of the proceedings ceased at the end of the inquiry in this case. And I accept that there are a procedural, yes, the procedural differences. I accept that in terms of the way that information is to be adduced and exchanged and challenged post inquiry. It's different. I accept all of that. But I don't accept that any of those procedural differences affect the fundamental principle at large.
You say the principle is a principle of finality, that you should bring your whole case forward, and if you don't bring your whole case forward, at least before the decision is made,
yes.
Then that's an end of it. It may well be that there are exceptional cases where the decision's been made and there's something that rises that might want you to challenge the decision after the event, but that's not Mead anyway. You're not dealing with that situation.
Right.
Here we're dealing with a situation where there's something that would be material to the decision, ex hypothesi, but nobody has actually drawn it to the attention of the Secretary of State, and we're not in the territory of the Secretary of State being the only person who knows about it, for example,
That's right.
which is where you've got the or the line of cases which say, well, if it's something that the Secretary of State knows about and the parties don't, then obviously the Secretary of State still has a duty to take it into account.
And the consequences of me being wrong about this, if I were to be wrong about the question of principle, are or risk being quite wide-ranging on my submission. There are many, many, many thousands of planning appeals. There's more than 10,000 planning appeals a year. And the public interest that Mr. Justice Holgate identified in finality of these being able to be concluded in a way that is efficient but fair, not just fair to challengers, but fair to everybody involved, is of enormous importance, obviously recognised for many years in the courts. And I'm not for one moment suggesting that seeking to characterise the case before this court at the moment, but just take a different case, a hypothetical case, not this case, where a putative challenger to a permission for something or other thinks, well, we've seen that this new evidence base or whatever has been produced. Let's not mention it now. Let's just see what happens, because if no one else picks up on this, this could well give us an opportunity to bring some sort of legal challenge on the basis of failure to have regard to material consideration. And it's that kind of mischief. And again, I'm not for one moment suggesting that's what happened, and not for one, there's no evidence about that at all.
When I asked for the evidence, it was clear they said they didn't know, and they've done small statements to say they didn't know.
Yeah, if I could just let me just get that statement.
But you know, what's the court to do? On the one hand, you've got a group of very naughty people who are keeping things back. On the other hand, you've got the public interest in having a planning system that doesn't grant permission for things that shouldn't have permission.
What is
So
said?
you're stuck.
What is said is that they didn't have the benefit of professional advice to know that new information or material, as opposed to comments, could be submitted, and they were mindful of reputed cautions.
Yeah, so
That's
I mean,
fair enough, but it's not that that doesn't directly address what the
Doesn't
judge's
quite nail
criticism
the
was.
point,
It
but
doesn't
it doesn't.
quite now. To be fair, obviously that we take it as far as we can, but the judge below made a pretty clear finding about this, and
well,
it's
she
not.
found it was an explanation, but not an excuse.
She found that she had no doubt that they had sufficient competence and skill to do exactly that, to raise the. If they thought the issue was worth raising, that they would have, could, should, and would have raised it. So, but putting the facts of this case aside for a moment, the mischief that Mr. Justice Holgate, one of the mischiefs that Mr. Justice Holgate was seeking to, in my submission, address in Mead is precisely the scenario that I've just painted to the court. And were it possible to follow exactly that sort of stratagem for good reasons or ill, then there is a serious, profound adverse consequence to the public interest of these many thousands of cases every year achieving.
What about the thing I postulated?
Oh, sorry.
They're about to build a block of flats
Yes.
on the Green Belt. Well, they're about to build a block of flats on something that's not currently in the Green Belt. And 2 nights before, they discover that, lo and behold, an inspector has decided and approved a local plan that makes it past Green Belt. And they think, we won't say anything for the next 2 days, we'll wait and we'll strike the morning after. On the one hand, as a court, we have the law which says you shouldn't have planning things done on a green belt. On the other hand, we've got a group of people that you think are going to run the risk of costs and so on in bringing it to light at a later date.
On that hypothetical that my lord puts to me, we are in qualitatively different territory, because if what we're talking about is the very late adoption of a new local plan that
I gave that as an example.
Oh, okay.
What it has to be is something that's so obviously material that it's irrational.
Yes.
It's not anything. Oh, we've just heard that there's a new traffic survey.
Yes.
6 bicycles and 4 cars, or 3 bicycles and 1
Yeah.
car. If it's not obviously material,
Yeah.
which is a rationality test, not anything that might make a difference.
Yeah. Fine.
Then
In that scenario, good news, the first instance judge has a discretion to exceptionally admit that material in, as in to formulate a legal challenge. Then we get on to the substance of the challenge. Is it a good challenge or bad? We'll see.
So does the judge then have to decide that it's obviously material before deciding whether to admit it?
No, the judge couldn't do that. The judge would have to, as in the judge would go on to consider the merits of the challenge subsequently. This is a procedural.
So what actually comes into play in the procedural stage? That there would be questions of the knowledge and the opportunity to raise it before the decision was made,
That's right.
which would be a factor
It
that
would
one
have
would
to be a
take into
factor.
account.
Yes.
And also some sort of preliminary evaluation of the merits of the
Yes.
argument that it's material in the irrationality material
all
sense.
of that. A prima facie analysis of might this end up being material? We don't want to rule it out yet, but at the procedural bar, but might
Yes.
it? But then also critically, just as my lady says, when did it arise? Could it have been raised? Should we allow this in exceptionally? And such a scenario as my lord posited would be, to be fair to Mr. Justice Holgate, it would be a million miles away from the facts of a case like Mead, because
completely.
there the arguments were all sitting there ready to be made at the inquiry, and it was decided for whatever reason that they not be made.
Not a million miles away from the facts of Cumberland and
No.
Bath.
Yes.
I mean, where I think this is boiling down to is the distinction, it seems to me, between the parties is boiling down to this. You both say it's a matter of discretion and not an absolute bar. But you say, well, the discretion as a matter of principle would always be, would be generally, if not always, exercised against allowing it if they could and should have raised it. Whereas it said on behalf of the claimant that is just a factor to take into account, and there may be some cases where even if they could and should have raised it, take Cumberland for example, that's not the be-all and end-all, because the materiality is so obvious and so great that will outweigh the considerations of procedure and finality.
I don't seek, as I've said already, to circumscribe in my submissions. I don't seek to circumscribe the considerations that may be relevant to the first instance judge reaching a view on whether to exercise their discretion exceptionally. I do say, however, that when my learned friend says that, well, Mead should not operate, to short circuit what he says, Mead should not operate as a procedural bar to CIDES, it should all be wrapped up into the CIDES consideration. My submission is that does not reflect a proper analytical understanding of these stages, because CIDES is something different. Yes, of course, the considerations...
CIDES is substantive.
So yeah, but subject to that qualification, then yes, the way that my lady's just outlined the positions is what it boils down to.
Yes.
That's it. And I don't seek, the Secretary of State doesn't seek to lay down absolute bars and rules. There will be difficult fact patterns that arise. We don't say that this is one of them.
But you say, as a matter of principle, if they could and should have raised it before the Secretary of State made the decision, then that ought to put it on that side of the line, on the Mead side of the line, rather than on the side of the line of letting it in and argue it.
I do say that, and on the facts of this case, I have to, as the court's made clear, and I accept, I have to do that by analogy to the facts in Mead.
Yeah.
But I do say I do it relying on the principles in Mead, but I accept it's an extension of the fact pattern from Mead.
Yeah.
Last question, there's an oddity then. Why have Regulation 17? It shouldn't say may disregard evidence. It should say you should normally give the evidence, even if it comes afterwards. I mean, the clear message from Rule 17 is don't put it in. It doesn't prohibit it, but it certainly doesn't require it or encourage it.
No, it doesn't. Well, it doesn't. It does neither. It neither encourages. Let me just get Rule 17 up. So sorry. This is called Core Bundle, page 120. And it certainly, as I think was said by my learned friend in his submissions after lunch, it certainly envisages the possibility that new evidence or new material may arise, and it seeks to deal with that eventuality. And it says at 4, it talks about written representations, evidence, or any other document received. Doesn't say by whom, but one's assuming there that it's presumably going to be received by the parties to the appeal.
When making his decision, the Secretary may disregard any written representations, evidence, or other document received. It must be by him after the inquiry.
Oh, received by him, but from whom is what I mean. Yes, no, received by him, but from the parties to the appeal. That's what I'm speaking to. So it envisages the possibility of this happening. It does not mandate him to disregard them. It leaves the options procedurally to the Secretary of State as to how to deal with this situation. And if indeed he decides to take into account new evidence, etc., new matters of fact, then it sets out at 5 how he is to go about considering that scenario. But I don't say that Rule 17 pushes the dial in one direction or the other. It's neutral to my case. It sets out, it envisages a situation where materials received post-inquiry, pre-decision, well, such a situation precisely eventuated here, so we know that can happen on the facts of particular cases. And then it says, Secretary of State, you decide, do we need to reopen the inquiry, or can we just deal with this through written representations back and forth? And that will always be, obviously, a fact-sensitive question of judgment here. And on the facts of this case, he decided that it would be fine to do it in writing when it came to the new housing numbers, etc. So that's an example of Rule 17 in action. But I don't say that Rule 17 detracts one iota from the principle that flows out of Mead, accepting that this case would be applying that principle to a different fact pattern. So fundamentally, the problem with ground one is that it is comparing apples with pears in my submission. It is taking a line of authority that's all about the duties on decision makers and making sure that they have regard to all things they have to have regard to, etc. With which we obviously have no issue whatsoever. And it is saying that such a line of authority is inconsistent with Mead. But the problem there is that Mead's not about that. Mead's about the circumstances in which you may or may not be able to actually bring a legal challenge as a matter of procedure. And Mead itself also is not absolute, as we've just seen, but is subject to judicial discretion. Now,
That's it, really.
that's the number one to say about ground one. I've obviously got lots of suspicions about ground two, but I'll leave those unsaid, and unless I can assist the court any further.
Thank you, Mr. Simons. Banner, anything you want to add?
Very briefly, just I adopt what Simon said, and can I thank the court for granting the expedition sitting on Friday. You may have seen a letter from CMS dated the 27th of March. These proceedings are costing one of my clients £100,000 a month, which leads me to our second point, my lord, which is that in my submission, the apparent failure of ground two is fatal to the appeal. Because ground one is really the gateway, the threshold question, and ground two is the substance. If the court is in agreement with me on that, I would respectfully invite the court, if you felt it appropriate, to indicate at least your decision at the end of the day, with reasons to follow, to mitigate the commercial prejudice to those behind me. In terms of the issue of principle, my lady, I had in fact written down could and should have before the words left my lady in Justice Andrews' mouth. But if I may, I thoroughly endorse that formulation. In my submission, the underlying principle in all the cases, when one asks why did the court find what it did in West? Why did the court find what it did? Strip away and go right back to basics. It is precisely that. If somebody could have raised, or at least sought to raise a point, could have done, should have done, but didn't, ordinarily, absent something special, that point shouldn't be entertained in this court. Otherwise, that would, amongst other things, encourage tactical silence, as well as undermine the principle of finality. And as to my Lord Justice Lewis' point about public interest and planning, that's not an absolute consideration. There is no principle in planning, nor can there be, that decisions have to be perfect, have to be.
Good idea for the other
You find for the movie.
Formal and fashion.
Judgments, of course, no matter, no pressure. But the system will become unworkable, and to a significant degree, the planning law regime entrusts the public interest in getting the right decision to the protagonist in a particular case to put forward the arguments. Otherwise, one can come forward and say the local authority should have taken this, that, and the other point, and they didn't, for example. My ladies and my lord, next point is it's important that, as Mr. Simon said, that paragraphs 75 and 76, the factual findings of Mrs. Justice Lamb below on the could and should have points, are not challenged. Very hard to challenge factual points anyway in this court. And nor does the appellant challenge the finding of absence of exceptional circumstances, if indeed exceptional circumstances are required on the gateway point. The last matter I wanted to draw the court's attention to is...
in terms of the discretion, this has been painted as a procedural bar. You don't get into the merits, you look at the discretion. But isn't one of the vital elements as to whether or not the discretion should be granted, whether or not it is so obviously material it ought to go into the balance, not just an ordinary consideration, but something that really is so obviously material, it's irrational, unlawful to leave it out. And for us to stop looking at that on procedural grounds and say, oh, they should have known earlier, they should have twigged that they could have written in it earlier, or paid for somebody to tell them that, without looking at the actual substance.
There's a degree of blur between the two. I mean, in a sense, one takes a holistic... It is a separate question, ultimately, whether it's the proper characterization is procedural or question of discretion.
Well, that's why I suggested to Mr. Simons that perhaps the right way of looking at it, or one way of looking at it, is to say, well, at the stage when one's looking as if there's a procedural knockout, if I can put it that way, the judge at that stage can't be expected to put the cart before the horse and decide that it is a blindingly obvious material consideration. He or she is going to have to take a value judgment as to whether or not that is realistically arguable. If it's realistically arguable, then the question then comes into play as to whether it's a matter for discretion and whether or not the fact that they could have raised it earlier is a knockout blow, or whether it's something that just feeds into the overall discretion.
Yes, I agree. When listening to the argument, no one's run it this way, but it occurred to me there's perhaps a degree of analogy with the principle of suitable alternative remedy in judicial review. I wouldn't necessarily for myself characterise that as a procedural bar.
Right.
It's just part of the court's discretion, and the court may well knock out a case on that ground alone, but having considered the case in the round as well. That's why I say there's a degree of which one's metaphors as such, but it's almost as a Venn diagram overlap, if you like, between the two different. They are two separate concepts.
Well, that's why it occurred to me that perhaps, with respect to the judge, that treating it almost as a preliminary point is wrong, because you've got to look at the overall shape of it before you can make a decision on the first point.
I would resist any suggestion it's not a separate point, but as a preliminary point, I wouldn't push back very hard against that. It's a freestanding reason for
the freestanding reason for saying no, but it's not yes.
And on that very point, Maddie, can I show you? You've clearly read it because you've referred to it, but the letter that my clients wrote at the end of the written exchange, because it informs both points. Actually, it goes to both ground one and ground two.
That was your clients, was it? The letter saying we want to cross-examine everybody.
Yeah, yes. Well, can I just show you, because actually it pulls together a number of the strands that have been discussed there. It's a supplemental bundle, page 333.
Yeah.
And as you have picked up, this was in response to references, albeit not in the context of any submission that we should fail, but references to ARUC.
Yeah.
In actually Mr. Stinchcombe's client's material, the written reps, and picking up at the last full paragraph, the ARUC GBR.
Yeah.
We said the ARUC GBR was prepared as part of the Council's emerging evidence base in support of the draft regulation plan. The evidence base emerging local plan carries no material weight. That was how we put it, contrary to what Mr. Riley Smith said. No material weight. We highlight the following points in particular. Then the Council's response to the consultation has not yet been published. And just for your note, it wasn't right for Mr. Riley Smith to say ARUC wouldn't be examined. Regulation 22.
He said it would be, I thought.
I think initially said it wouldn't be.
He said it would be. I asked by whom and who appointed. He said an inspector appointed by the section states.
In which case, apologies, but no, it's definitely was sub judice at the time. So the response to the consultation has been published. Then the second point my Lord Justice Lewis emphasised a couple of times today, not being relied upon the Council, whose document ultimately this was. It's inconsistent with the Council's evidence in the appeal, including concessions made in cross-examination. I think given the time, if I may, I'll just give you the references.
Yes.
So Inspector Report 550, which is the paragraph my Lord Justice Lewis emphasised a couple of times, and 542, both refer at the end in square brackets to an earlier paragraph, 78. And that was in the bit recounting, for the Secretary of State's benefit, the submissions made by Mr. Henderson and me of the inquiry. And 78, which itself refers back to 77, if you want to see it, I can take you to it. But that's supplemental bundle. Maybe we should have just the same bundle. 78 and 77. Page 27 of the supplemental bundle. Noting the Council's own expert witnesses accepted in cross-examination that my client's development caused the minimum possible harm you could possibly get anywhere in St Albans for development of this scale. So irrespective of the Green Belt's review, the Council's own position at the inquiry, not gainsaid in closing submissions, and something which we reminded everybody of in our letter, was that this development, because of course the Green Belt Review didn't look at development, it looked at sites. This development caused the minimum possible harm you could get for this amount of development, and it also accepted that some development had to come forward before the new local plan. It's in 78. And when you get to 542 and 550, Inspector refers back to those paragraphs in the standard formula where an inspector endorses a submission, they refer to it in square brackets. So that informed what, going back to paragraph 330, page 333, our letter on the 16th of February, that informed what we said in the third bullet, inconsistent, Arup was inconsistent with the council's evidence in the appeal, including concessions made in consultation. Then the stress not referred to in the council's own written material. The point about the inquiry, which is in the penultimate paragraph, there's no concession that this was so material. Simply, if you're going to, in any way, if you're thinking about holding this against us, we need to be able to test it. That was the point made. Now, critically, my ladies and my lord, critically, once we've written this, no one responded or gainsaid it at all. There was complete silence in response to this letter on this point. It not only my submission, but essentially a finding of the courts below, that it would have been open to the, at least reasonably open to the appellants to say, hang on, please can we come back on this? They did.
So you say it's not just a situation where they could have raised it for themselves, but you flagged it up and they don't say anything
Absolutely. Absolutely. So again, exactly. It's not just they didn't raise it, but we said it can't be raised, and they didn't gainsay that. So when we get to the decision letter,
Don't forget that first of all, they were supposed to put in submissions by the 12th of February, which they did do, and there seems to be the second round. This is dated the 16th.
yes, because it was the first round of submissions that raised for the first time in decision compliance the Arup report, and we were like, hang on a minute, we need to come back on that to put the marker down that we did. But then when you get to the actual decision letter, that letter, which wasn't responded to, wasn't gainsaid by the claimants, that is referenced in the decision letter.
Yes.
It's paragraph 9. It's one of the Annex A letters. If you paragraph 9, which is at page 338 of the core bundle, there's other representations that we received since the inquiry is that Annex A. Secretary satisfied the issue raised, don't affect his decision, etc. So it's not just that they didn't raise it, not even just they couldn't, should have sought to raise it, but we expressly said it shouldn't be raised for a number of reasons, and they didn't respond to that. So how can it be
And
said?
the Secretary of State appears to have thought that it wouldn't affect the decision,
Correct.
the ultimate decision either.
Correct. Correct. So how, in that situation, can it be said to have been unlawful in any way for the claimants for the Secretary of State to have taken that letter at face value, essentially?
Yeah.
My lady and lords, there's not more I could say, but I don't consider it necessary unless you've got any questions.
Yeah, can I just raise
Yes.
one point which occurred to me during the exchanges? Would one approach to the exercise of this exceptional discretion, if your submissions are accepted, be for the decision that the judge, because it would usually be a judge, to assume for the purposes of exercising the discretion that the consideration is an obviously material consideration, and having made that assumption in favour of the claimant, then go on to consider whether or not the claimant is barred from raising it in the proceedings because the claimant could or should have raised it earlier.
Sort of Dave Ben Ayre
Yeah,
approach.
yeah.
That one, yes, I mean that would be consistent with what I said earlier in terms of the overlap. It may not be the only
No, I mean,
permissible way of doing it,
as I
but
say,
it would
just
be a sort of working formula if the court was looking to provide the High Court with guidance on how to go about these sorts of cases. I can see the force of that. Thank you. Thank you, my lord.
Mr. Stinchcombe.
Very, very briefly. You'll see, and it's related entirely to exchange of because you'll see that in our scope of argument we reversed rounds 1 and 2. And we did so precisely for the reason that on the circumstance of this case, it seemed to us to be plainly obvious that this was not a mandatory material consideration, in which case the procedural bar never arose, and Heidi's never arose. But to the extent that that academic question is raised for consideration now by this afternoon's engagement, our submissions are at 34 and 35 and 56 of the skeleton. We say that the principle of law applied in really does read through to post-inquiry matters, but where a resident or a third party or a party is aware of a material consideration, could and should have raised it and had no proper justification for failing to do so, then ordinarily the general principle excluding it would arise. But it's quite clear that there are different circumstances that apply in terms of whether there is a proper justification, where it arises after the event. And that's a matter for the discretion of the court, whether to allow it to be admitted. But I do respectfully submit that our general approach is the preferred one, especially in cases such as this, that where consideration hasn't been raised but isn't material consideration, obviously material consideration in any event, then it should be ruled out on that basis, and we don't even get to kindness. Unless I can help you any further.
I can see an odd world where whatever decision we give, it is going to make the situation for everybody far worse. Everyone's going to be writing in, just in case Mr. Simons appears and says, oh, no, too late. So they have lots of things to go through. At the moment, one might think if they haven't raised it and they know about it, certainly if they're the council, less so for a pressure group, you've got what Mr. Holgate said, really, it's not irrational, you can't treat it as material if they haven't said it. So that would be a filter, but that'll have gone because they'll all be writing it in. So it's just going to make it worse. You're going to have, it's not your problem, it's Mr. Simon's problem. But this, the result of this is the advertising of the possibility of things not being considered and the encouragement to do that and the need thereafter for the courts to filter out which of those were material and which of those were not. We're going to have the worst of all possible worlds, aren't we? You say that's not your problem.
But my lord, in circumstances such as this, where the body that commissioned the Green Belt Review and the body that refused permission didn't bring the matter to the attention of the decision maker, didn't bring the matter to the attention of the court, didn't bother to turn up and support the challenge, then that at the very least goes to whether it's a material consideration in the first place.
And they didn't take part, they obviously didn't bring it to a data review, they didn't, I can't remember, they didn't put any acknowledgement of service at the commission stage and they're not taking part below water.
No, not at all. Right. This will be of any further assistance.
Mr. Elisabeth.
My lady, if I may focus my fire on the first of the grounds really in relation to this point of principle,
Yes.
rather than in relation to ground 2. I'll focus on that and responding to effectively the submission to extend Mead to apply to the different factual situation where material consideration arises after the inquiry but before the decision. And I think your ladyship is correct in recognising it's never been the appellant's submission to say that these points are not relevant. It's the time in which they come into the consideration of the court. And we push strongly back at the submission of effectively making it a preliminary consideration before getting into CIDES. The reason for that, and to pick up on your lordship's concern about what happens as it were after this, these points are already reflected in the CIDES approach and the considerations that must be done. If, as is here, a party has not raised it, then they will face the difficulties this appellant has faced on the obviously material test. Equally, not the case here, but they could face the difficulties in terms of the knowledge or reasonably ought to have known consideration. So the preliminary bar isn't, as it were, adding anything. It's just requiring the court to look at, in a way that is slightly unclear, a slightly more narrow question, which therefore, as your ladyship notes, might have to have them to assume whether it was so obviously material. We would say the approach set down by the Court of Appeal in CIDES and applied since, it doesn't need to be changed to add in that preliminary bar. It already encapsulates these issues in a way. And the real concern, if that preliminary bar is added, and this is where, while I appreciate my learned friend's submissions on the cases go to a procedural point versus a substantial, the appellant would submit that it's important not to lose sight of the statutory duty at the heart of this, which is the statutory duty on the Secretary of State or on the decision maker and on no one else to ensure that their decision has been made with due regard to material considerations. And the effect of a preliminary bar does give a route for absolving the Secretary of State of a failure in doing that. And that, we say, cannot be right.
and some in some circumstances, so does Mead. Because if you assume in a Mead situation that they've got a blindingly obvious material consideration, but it hasn't been taken into account, it's too late to deal with it, then inevitably you're in a situation where there's a decision that's been made without the proper approach to the statute.
And while we accept one analysis, but it's not the one that the appellants put forward, is Kydes exists as an exception to the general rule, but we don't ask you to find that. We think that is starting off on the wrong footing, which is effectively what the first respondent asked. That isn't the correct correct approach. It would also run contrary to Bath Society and also the DLA delivery with appeal decisions where it goes so far as to say if no one has raised it. And what we do say is the unusual feature, and this is what supports the absolving point. The Secretary of State did know about this material consideration through other means, not by the appellant, but through other means.
Well, he didn't know about the conclusions of the out report. He knew there was an out report, that's all.
Knew there was an out report, also knew that it came to different conclusions as to the sites. But yes, well, but taking this as a point of principle rather than, I appreciate the courts potentially on ground two, but it's a really important principle, which is why I hope to deal with it in reply. It would have a significant chilling effect, we say. And this is where I return to your Lordship's point on where the balance lies. The practical flexibility recognised in Kydes is only so far as the court needs to know. The control mechanism against this is the tests of so obviously material and knowledge. And that's what doesn't open, either in one way, the floodgates to all material considerations that arise being relevant, but equally on the other side of the equation, it doesn't prevent any material consideration that was relevant and known about still being able to be challenged on if the Secretary of State has missed it. And what we do say is none of the three respondents have really grappled with the practical implication point raised by the appellant as to if it's a claimant who wasn't involved in the appeal, or if it was an appeal that didn't have a third party. What is the ability of those members of the public who wish to challenge this? And it could be said, but we would say it would be an incredibly harsh finding to say, well, member of the public, you could have got involved in the inquiry and then you could have raised this, even though it emerged afterwards.
And on the tactical fear, the person who doesn't take part is better off. He waits patiently. He sits in the dog and duck and waits until the decision comes and then he strikes.
And that was my next point.
What if he's sitting in the dog and duck?
How do we address the dog and duck risk? It's this: the mischief is dealt with already by the stringent nature of the test in Kydes. If you sit there and take the risk of not producing it, then you have the risk of, as your Lordship has put, well, if it was so obviously material, why didn't you raise it? And the risk of the Secretary of State saying, well, no one raised this to me, and therefore I don't have knowledge and can't be said to have reasonably known to have knowledge. So that mischief is dealt with already in the stringentment of that test, insofar as it can do. And it would be, if I may respectfully say, an overreaction to that hypothetical mischief to remove the ability of members of the public to challenge where a material consideration has not been taken account of. Because as well as Mr. Simon's concern of the dog and duck patron, there may be others who for genuine reasons have not been able to raise it, were not involved, etc. And so we would say that principle would have an onerous effect on them. If I may end, and I'll make the submission and I'll just turn my back if I may. Again, to endorse your ladyship's encapsulation of the issue here, which is not should these factors be taken into account, but when. And we just say it would be wrong to say there are, at the start, a procedural preliminary bar that sets effectively the presumption against the person raising it. That goes too far, especially given the nature of the statutory duty. Equally, we say, because my learned friend has noted the cases of West and Mead and Appellant, they do deal with a different factual situation, and the authority that deals with this factual situation gives us a test and an approach. The second point, which perhaps has not been addressed so much, but I think important to say, is nor should it be the case that the CIDES test can be met. It's a so obviously material consideration. It was within the knowledge of the Secretary of State, but the failure of the challenger to raise it to the Secretary of State's attention absolves. It shouldn't come in at the end of the process as it were, a final hurdle to overcome. What we say is it is part and parcel of the CIDES consideration already. And so we strongly resist the first respondent submissions of extending need to cover this different factual situations.
When does it come in? It doesn't come in at the permission stage or as a preliminary hearing. It's beginning to sound a bit, because that's why I asked you when we did Bath, because if you go back to Bath properly, it said there was a breach of the law because there hadn't been no consideration of it. And then it went on to consider it as a matter of discretion, and it considered it as a matter of remedial discretion. That's why I picked you up on it. It may be that the way to deal with it is if you really do have the schema from the dog and duck in the row in front of you, you might say, well, there may have been a breach here, but in the circumstances of this case, this person does not deserve a remedy.
We say it comes into those two questions of so obviously material. It comes into so obviously material, as your Lordship has noted many times. You tell us it's so obviously material. Why didn't you raise it? So that's where it comes in relation to that. And that's not, we say, an insurmountable challenge, but it's one that therefore is a higher hill to walk up compared to if it had been raised. But that's not it being a procedural bar. Equally, in relation to, well, you didn't raise it, so we know, in fact, not this case, but we know the Secretary of State didn't know about it. Mr. Elisabeth, the only thing you can rely upon is that he reasonably ought to have known about it. But how can you say that when you didn't raise it? It feeds into that second element of that test there as well. But it's not therefore operating as a freestanding hurdle at either end, is what we say is the approach.
Right.
And that is what assists against that mischief, partly, the dog and duck mischief.
Yes. I know there is a dog and duck in Chiswell Green. It just sounds like the place that should have a dog and duck.
If I may just turn my back. Oh no, my apologies. There was one other point. Just to note and just to give the court the reference in terms of the Deputy High Court Judge's views on the adversarial part, just to note that's also referenced and endorsed by the Court of Appeal at Authority Bundle, page 201. It's quoted, in fact, between F and H.
Thank you.
But just note that it was something that the Court of Appeal also had regard to. If I may just turn my back.
Should we rise to consider whether we should announce to use
Just upon instruction, just a final point which I raised. I did say I'd make no submissions on ground 2, but just one, if I may, in response.
You can't, can you? We didn't call on your opponent.
Well, it was in relation to the correspondence that was sent, but no.
If you want to say something about the
What was known about the correspondence? I must say, speaking for myself, it would have been so much more helpful if the correspondence had been in chronological order. It's very difficult to work out who said what when, and some of them are not dated. They're January, February.
Yes.
You've got to go into the details to get a clue of when it might have been. But anyway.
Now my lord is offloaded about the correspondence. What point did you want to make, Mr. Elisabeth, about it?
It was just the point, and the reason I felt I could make it because it was a passage the court was taken to by Lord Banner.
Yes.
The reference to the materiality of the Arup report is that it was referenced as being material enough that if the Secretary of State were to rely upon it, they'd have to reopen the inquiry. It's just to note that there was that evidence as to the materiality of it.
If they're right, you make their position worse and yours better. And if you've got to do that, then it really must be crucial, or pretty crucial.
Well, thank you all very much. We're going to rise for a short moment to consider Lord Banner's proposition as to what we should do next. So don't go away.
Court rise is able.
It's a good idea.
Well, this is in Australia, I'm not sure.
I think it's only out by those two. I think just the distance.
It's such a classic thing that you don't understand. So it's
Yeah.
That's fine. Should the first pressure chance at the start was hit all around. Against all ground, that's it.
You know,
she's a real cut about it. And also possible things are I don't know him.
the ultimate cheat. Not it, pure bread.
Area. Yeah, I think it's a bit generous. Like, if you said to hold it, would you go for that? I think he'd be instead against it.
Yeah, go with it.
Because that you're going to get Stell, this is going to get off the ground there. She's going to leave the doorway for this.
Just clarifying,
Yeah. It's going to last 1,000 years. The microplastics are going to get into your skin.
which means on this to be beneficial.
First point, if there was issues, do you think they'll press it, like not see it? Because they'll say, well, because it fails on round 2 anyway. Yeah, it sounds quite.
Splash with the we have the oxygen.
That's why it's not very much.
It's about how actually so. One option is to say, well, it's always interested to see what is one of
as in set out
they're just going to say whether they're allowed to dismiss
oh no, sorry, not I meant in the original judgment. Will they actually due to their set out whether they'll extend it rather than take the approach of actually being
I know, yeah.
So excited.
Such a great authority.
I'm going to tell them what the difference is between DS2 Absolutely, look at that. What a waste.
The one thing they weren't interested in was the yeah, one of your specialist subjects. You can mastermind your.
Absolutely, yeah. Told them when it was adopted in 1994, it was subject to the requirement for a quote urgent review.
In 1994.
We'll adopt it, but urgent review, guys. Okay, yeah. 30 years, 41 years later. I wish I were. That's interesting, isn't it? Decorum also, there are these plans that are going to get waived under these places, but they're all going to be out of date next July.
background and
I've realised I have this moment.
Very interesting.
On what, sorry? That's been discussed.
One of the things I've realised that I probably have 100 problems. They all end in the same way. So we say, well, we're going to press ahead, and we're going to do this. We're going to do it in the next 2 months, or whatever it is. Yeah, at the moment. Of course, things have already started to slow down. I do wonder whether the wheels are going. I don't know. Because we some of my clients are now coming next year. So well, let's start getting commissioners here.
Following the defined as towns, dummy on the wall. There's something. That's quite sensible. I mean, that's sort of the humidity. We're not GC. It's the opposite one. Everyone likes to be finished with the play because they want to That's
Well, the appeal will be dismissed. The reasons why we dismiss the appeal will be provided in our reserved judgments, which we hope to get to you as soon as possible, and I'm fairly confident that they will be handed down before the end of term. I do obviously say thank you to everybody, including everybody sitting behind counsel, for their very hard work on this case and for the way in which it's been so ably presented today. The written submissions were first rate. I think that despite the fact that there were a few vagaries here and there with the bundles, on the whole we were greatly assisted by that, so thank you very much. Usual rules will apply. We'll circulate our judgments in draft. Everybody here is experienced enough to know that's not an opportunity to re-argue, it's just an opportunity to correct our typing and other obvious factual errors. There's no need to attend. We would be very grateful if there are any supplementary submissions, if they can be provided with the comments on the draft. If anybody needs any further time, please let us know at that stage. And if you can agree an order, so much the better. If you can't, just indicate to us where there are areas of disagreement, and we will deal with the matters on the paper. Thank you very much.
Rise of Able.